If it pleases the court, my name is Miles, spelled Marles, initial En, appearing on behalf of the Crown. The Crown brings an application pursuant to Section 590AA of the Criminal Code Queensland to seek a ruling against the competency and culpability of certain witnesses. My second submission will request that the evidence obtained by Constable Jones be admissible. Your Honour, my first submission. Pursuant to Section 91A of the Evidence Act, every person, including a child, is presumed to be competent to give evidence in a proceeding. In Hoskin, competence implies compellability. Therefore, Gareth and Lara are both prima facie competent and compellable to give evidence. The Crown acknowledges that Payne takes the position of co-accused who are indicted and tried together cannot be a competent witness for the other. Due to this, the accused is not compellable to give evidence against their co-accused. Based on these facts before us, Gareth and Lara would both be considered competent under Section 9, but not compelled to give evidence against each other. Pursuant to Section 8.2 of the Evidence Act, the spousal relationship of Gareth and Lara does not have any impact on their status as co-accused takes precedent over their spousal relationship. The Crown concedes that Gareth and Lara are both competent witnesses and seek an order from Your Honour to sever the indictments so that the accused are able to give evidence against one another. The Crown anticipates the defence will raise competency issues pursuant to Section 9A, supported in Chalmers, in respect of Trent's age and mental disability. Pursuant to Section 91A, children are presumed to be competent to give evidence. Under Section 9A2 of the Evidence Act, it is in the court's opinion whether the witness is able to give an intelligible account of the events that occurred. It is in our submission that the court will be able to conclude that the witness be capable of providing an intelligible account of the events and rule Trent competent. Trent's interaction with the officer in his 93A supports such a submission, interacting satisfactorily, recalling details from the night of the act, thus indicating he understands that he is taking an oath and knows the difference between a lie and a truth. This vulnerable witness falls within the definition of an affected child witness because the proceeding involves grievous bodily harm, and a prescribed relationship of parent-child exists between the co-accused and Trent pursuant to Section 21AC. As such, the Crown submits that the principles within Section 9E and 21B adhered to. It is further submitted by the Crown that the child's evidence be taken in the usual manner pursuant to Section 21AK. The court would have no concern with regard to Trent's age affecting his competency, but what might be of more concern is his diagnosis of being autistic. At this stage, the details of his condition are unclear, and under Section 9C2, without the admission of expert evidence, it is difficult for the court to make an accurate assessment. Maud is prima facie competent and compellable to give evidence against the accused. Competency issues may arise due to the witness's mental capacity with speculations of dementia. However, the law does not preclude Maud giving evidence and is a question for Your Honour whether Maud is able to give an intelligible recount of the events that occurred. The Crown submits that since Maud experienced the attack firsthand, she possesses a memory which is vital to the Crown's case. To assist Your Honour coming to such conclusion, expert evidence should be sought pursuant to Section 9C. Further, the Crown requests the use of a hearing aid for Maud to allow her to participate fairly within the trial. Please note, Your Honour, the fact that the police noticed Maud spoke slowly and softly is not evidence of someone who is on cognitive decline. Prima facie, Sally is presumed to be a competent witness to give evidence, as there is nothing on the facts before us that would raise any concerns. The Crown submits that Sally is able to give an intelligible recollection pertaining to what she heard while under her bed the night of the assault. Your Honour, I turn to my submission as to admissibility of the CCTV evidence. It is ultimately submitted that Gareth, upon being asked where the CCTV footage was stored, consented to Constable Jones accessing his phone to obtain such footage. It is conceded that Constable did not obtain the appropriate warrant pursuant to Section 151 of the PPRA, nor made the appropriate application for a post-search warrant pursuant to Section 160. However, the Crown submits that Constable Jones suspected the footage on Gareth's phone may be destroyed and took the evidence as a genuine response to the pressing circumstances. Prima facie, the evidence obtained by Constable Jones was done so unlawfully. In such circumstances, the court must make an assessment as to whether it should exercise its discretion to exclude such evidence from the trial, taking into consideration the principles founded within the case of Bunning and Cross. The Crown submits that the court should not form the view that the constable deliberately breached his obligations pursuant to the Act. It is submitted to be reckless. Premised on the officer's misunderstanding as to whether Gareth provided consent for him to access the phone, which must be viewed within the context of the search, whereby the officer asked Gareth as to where the footage was stored. Gareth, who at this point would have been aware why such a question was being asked, directed the officer that such footage was stored on the phone, then further directing him to its location. Constable Jones then formed the view that Gareth had provided consent to view such footage. However, by not obtaining specific consent or the appropriate warrant, Constable acted recklessly. Your Honour, we bring to your attention the seriousness of the act occurred. We have two adults inflicting grievous bodily harm on a 64-year-old woman, suffering from profound hearing loss, who as a result of the attack is now further impaired by being deaf in one ear. The Crown submits the documentary evidence is extremely cogent to the present offence and vital to the Crown's case, thus should be admitted because it is more convincing than any witness. Your Honour, relying on the test from Bunning and Cross and taking into consideration Section 160 of the PPRA, the Crown does not believe there is any basis that is reasonable to exclude the CCTV footage as evidence. If there is nothing further, Your Honour, that concludes my submission.